Hello, everyone. Welcome to the last week of the 2020 Hot Topics in Environmental Law Summer Lecture Series, brought to you by the Environmental Law Center here at Vermont Law School. I'm Jenny Rushlow. I'm Director of the Environmental Law Center and Associate Dean for Environmental Programs at VLS. I'm going to bring up a list of resources on the screen to direct you to some of the programs at the Environmental Law Center for those of you view our full Hot Topics lineup with the one remaining talk this week by going to the website vermontlaw.edu/hot-topics. Each talk is worth one Vermont CLE credit, so please keep track of which talks you attend for your records. We'll have time for question and answers after today's presentation, so please type your question in the chat box at any point during the lecture and we'll get to as many as we can in the remaining time. Today, we are so pleased to welcome Professor Robert Percival. Professor Percival is the director of the Environmental Law Program and the Robert F. Stanton Professor of Law at the University of Maryland Francis Carey School of Law. He served as law clerk for Judge Shirley Hofstadler of the Ninth Circuit and for Supreme Court Justice Byron White, and spent 6 years as an attorney for the Environmental Defense Fund. He has served as a visiting professor at Harvard Law School and Georgetown University Law Center. He's the principal author of the most widely used environmental law casebook. He was a Fulbright Scholar at the China University of Political Science and Law in Beijing in 2008, and has worked with the China's Supreme People's Court, the National People's Congress, the Chinese Ministry of Environmental Protection, and the China Council on International Cooperation for Environment and Development. He has presented lectures at 27 Chinese universities, and in 2009, he represented the U.S. State Department on a lecture tour in China. This is Professor Percival's 6th year in our summer program, where he co-teaches the course Comparative U.S.-China Environmental Law with VLS Professor Yanmei Lin. Today, he'll present the talk, Greening China's Belt and Road Through New Measures to Promote Transnational Environmental Accountability. Please join me in welcoming Professor Robert Percival.
Thank you, Jenny. It's a real pleasure to be part of Vermont's summer program. I only wish that we could be doing it in person this year and then taking the students to China as we've done in past years, but I hope that option will be available next year. I'm going to share my slides now on my screen and share my screen. So you should see the slides. And good. What I'm going to talk about is related to the comparative U.S.-China environmental law class. And it refers to a project that we've launched at Maryland that was inspired by China's Belt and Road Initiative. China, for a long time at the beginning of the new millennium, had a Go Out, Go Global program. But in 2013, Xi Jinping greatly expanded this by announcing a program to promote massive infrastructure investments to build road and rail transportation following the old Silk Road, as well as what he called the Maritime Silk Road, a Belt and Road to involve hundreds of billions of dollars in investments in infrastructure, in ports and rail and roads to link China more towards the rest of the world and improve trade. China also created the Asian Infrastructure Investment Bank that the US was very skeptical of, but it soon became very popular, and most other developed countries joined in with that. Now, what our project does is it tries to look at how can we ensure that the Belt and Road Project does not damage the environment, particularly of poor developing countries that have these infrastructure projects in it and extractive industry projects. Start with the fundamental principle of the global environmental law as acknowledged in Principle 21 of the Stockholm Declaration and Principle 2 of the Rio Declaration, that states do have a responsibility to ensure that activities within their jurisdiction or control don't cause damage to the environment of other states or of areas beyond the limits of national jurisdiction. Now, while that principle has been viewed as uh, one that promotes controlling transboundary pollution, I submit that it also means that countries have a responsibility to ensure that the activities of countries that are based, of companies that are based in their countries, don't cause harm in developing countries. Now, the US, since the first Congress, has had the Alien Tort Statute that expressly allowed foreigners to sue in US courts against anyone who committed a tort in violation of the law of nations. One of the most celebrated instances of this was litigation brought by residents of Ecuador against the Texaco Oil Company, later taken over by Chevron, for polluting the Oriente region of Ecuador. They filed suit initially in US court in 1993 in federal district court in New York. But Texaco and later Chevron said no, the case should be heard in Ecuador. And they eventually got the case dismissed on grounds of foreign nonconvenience in the year 2000. The case was refiled in Ecuador in 2003. The US courts have said, we're only going to dismiss it if you accept the jurisdiction of the courts in Ecuador. So it was refiled in 2003. It took 8 years to litigate. And finally, in 2011, the court issued a $9 billion judgment against Chevron for the costs of cleaning up the heavily polluted Oriente region. But Chevron adopted a scorched earth policy in response to the decision. The Wall Street Journal, in a laughable editorial, said that this is the result of foreign shopping, global foreign shopping with US trial lawyers and NGOs trying to hold American companies hostage in the world's least accountable and transparent legal systems. Of course, problem was they wanted to sue initially in New York federal court, and it was Chevron and Texaco that insisted, no, we want the case filed in Ecuador. Well, ultimately, Chevron, in its scorched earth legal strategy, filed a RICO suit, racketeering suit, against all the plaintiffs and their lawyers, and a very friendly judge ruled in their favor. So it's been impossible to collect the judgment, largely because where they've tried to collect it in Brazil, Argentina, and Canada, the courts have held that the Chevron subsidiaries there are not responsible for the sins of the parent corporation. Similar thing has happened with respect to the pollution of Nigeria's Ogoniland. Back in 2002, Shell Oil had been environmental activists in this area of Nigeria had been trying to get Shell Oil to clean up its act, and they were arrested and executed by a military dictator who ruled Nigeria at the time. When their survivors brought suit in the United States, um, the some succeeded. Ken Saro-Wiwa's survivors got a settlement of a lawsuit under the Alien Tort Statute, but ultimately the U.S. Supreme Court in Kiobel versus Royal Dutch Shell in 2013 held that the presumption against extraterritorial application of U.S. law meant that the Alien Tort Statute could not be used for harm that occurred abroad to foreigners. And the court was split 5-4. Justice Kennedy held open the question that maybe if the violation of international law principles was serious enough, that it would be sufficient to allow such a suit to be brought in the US. I thought it was quite a stretch because the presumption against extraterritorial application of domestic law didn't even exist at the time the Alien Tort Statute had been adopted by the first US Congress. Um, Last year, however, the Supreme Court encouraged transnational environmental accountability in a case involving the Tatra Mundra power plant in India. The International Finance Corporation, which is located in Washington, D.C., had approved a loan to fund this coal fired power plant under strict conditions for protecting the environment. When those conditions weren't honored, a lawsuit was brought against the International Finance Corporation for refusing to enforce those conditions. The case centered on a very interesting question of statutory interpretation concerning the Foreign Sovereign Immunities Act, and the court ruled that the International Finance Corporation was not immune from suit over commercial activities that it engaged in. However, this was a short lived victory because on remand, the lower court said that the commercial activities took place in India, not the United States, and so the suit's been dismissed. The Supreme Court has recently granted review in the Cargill and Nestle cases, cases where the Ninth Circuit permitted an alien tort statute case for forced child labor in the cocoa plantations in Cote d'Ivoire to go forward. And I suspect this may be the death knell for the alien tort statute when it decides the Nestle and Cargill cases next fall. Now, courts in the United Kingdom have been more sympathetic to lawsuits brought for environmental harm and human rights abuses abroad. In April 2019, in the Vedanta case, the UK Supreme Court ruled that nearly 2,000 villagers in Zambia could bring suit against a copper mine in UK court, a copper mine in Zambia that had caused pollution that had caused them harm back in Zambia. The approach of the UK court seems to be to focus carefully on what corporate activities took place in the UK in supervising projects abroad. Vedanta is actually in India, a company based in India that tried to delist on the London Stock Exchange in hope of avoiding liability. Now back to the Belt and Road. This Belt and Road projects have affected more than 100 countries around the world. And in many cases, it's caused conflicts, including the notion that it's really creating what's called debt trap diplomacy, that the Chinese government lends so much money to these countries for infrastructure projects, knowing that they're not going to be able to repay, so that they can ultimately take over ports and other transportation facilities in these poor developing countries. Yet, nevertheless, Xi Jinping has promised that the Belt and Road is going to be a green Belt and Road. So, my friend John Jingjing, who's now a lecturer in law at Maryland, has come up with this notion of creating the Transnational Environmental Accountability Project, where the students research the various laws that apply and government policies from China that are designed to ensure that Chinese companies, in fact, honor local environmental laws and human rights standards when they operate abroad. I first met Jingjing when I was teaching at the China University of Political Science and Law in 2008. She had been subject of a couple of documentaries because she was a hard-hitting public interest environmental lawyer. And she was very sophisticated at knowing what was possible to do in China, despite the fact that it had an authoritarian government. The Communist Party had decided that it really wanted to promote environmental protection. And Jingjing said her purpose wasn't to oppose the government, but to bring public interest lawsuits. That was my class that where I first met her. It was part of Professor Wang Sanfa's Center for Legal Assistance to Pollution Victims, where Jingjing was employed as a public interest lawyer. And in this photo, we're posing with the Olympic torch that Professor Sanfa got to carry prior to the August 2008 Olympics. Now, what Jingjing did in China was she visited the sites where people were calling the hotline and complaining about pollution from all over China. Some Chinese mines and the pollution that they caused, other types of smelters and other industrial activities in China. And subsequently, Jingjing has now fallen in love with an American, got married, moved to the United States, and had two children. And she now lives in Bethesda, Maryland. She worked for the Open Society Institute for a few years. And she said a light bulb went off in her head when she visited Africa and saw that some of the same Chinese companies that she had been suing when she worked for the Center for Legal Assistance to Pollution Victims were causing the same types of pollution with the same harms in these poor African countries. So we created the Transnational Environmental Accountability Project that uses students from our environmental law clinic to work with professors from multidisciplinary fields to figure out how we can advance the cause of holding accountable foreign companies when they neglect the environmental laws in other countries. Our project was named a finalist for the Access to Justice Award by the World Justice Program. And last year we took students to The Hague for the World Justice Forum. Now, Jingjing's first big success was a case in Ecuador where a Chinese mining company was mining in a protected area. And the locals community had never been consulted about it at all. And so they finally were sufficiently mobilized that they were able to convince the Ecuadorian authorities to revoke the mining permit. And Jingjing went there when the revocation of the permit was challenged. She went to Cuenca, Ecuador, and she filed an amicus brief and appeared in court. And she said when she first arrived, the indigenous population thought she must be a lawyer for the Chinese mining company. She said, no, I'm on your side. Basically, what she argued in court was that under Chinese law, Chinese companies are required to respect local environmental law wherever they operate, as well as international human rights treaties and treaties that would require prior consultation with the local community. The revocation of the permit was upheld on appeal, and the local population was incredibly grateful for the services of a Chinese lawyer to try to hold Chinese companies accountable for not respecting local law. She's now turned her focus, among other things, to the country of Guinea, which supplies a huge amount of the bauxite used by China. I think about 1/3 or more of all of the bauxite that China uses comes from Guinea. And there are Chinese companies there that operate bauxite mines. She visited the area in 2018 and saw deplorable conditions where the company is, again, just ignoring the local standards. So she decided to organize a field trip for Maryland students where they could help assist the community. Professor Seema Kakade, director of our environmental clinic, worked on this project, as well as a professor from our School of Public Health. They studied carefully the legal requirements that China imposes on companies involved in operations abroad. And the clinic conducted interviews with people who had worked on human rights issues in Guinea and assembled this multidisciplinary team that focused on how we can make what's going on there more transparent back in China, what citizens need to know about citizen science that can help them assess the effects of the mine, and ultimately to be available to support potential legal action. So this proved to be very effective in that the ABA Rule of Law Initiative had already done a report on rule of law in Guinea, and among the things they found was environmental regulations like environmental impact statement requirements were routinely ignored or treated just as paperwork that the Chinese firms would pay attention to after already going over the head of the regulators and getting approval from the president of the country to go ahead with their mine. And then it was just after the fact paperwork. So Jingjing also decided that it would be important to partner with a Chinese environmental NGO. So Jinmei Liu of Friends of Nature China went with our Maryland students and faculty on this field trip to Guinea in June of 2019. Uh, it was quite an experience for the students, but the local community was particularly excited that in their struggle against this Chinese mine, they now had the assistance of a Chinese lawyer and a Chinese NGO and law students who conducted programs to help educate them about what their requirements were and what a local community could do. Now, one of the big problems in a lot of these developing countries is corruption. And we also have had a program with the University of Malawi that has established a sustainable environmental justice clinic. I took students over there in 2017 and discovered that while they have a very robust legal system, you may have heard they just had one of the few peaceful transitions of leadership after the Supreme Court of Malawi had struck down election fraud, and the opposition then won the new election. Um, we visited NGOs there, and there are lots of grassroots NGOs, including the Center for Environmental Policy and Advocacy. And one of the things they told us was that when they at least wanted a project that a Chinese mine had in Mozambique was trying to build a railroad that, as you may know from geography, Mozambique surrounds Malawi on three sides. And the railroad was going to go all the way across Malawi, and they needed approval from Malawian authorities. So the Malawian Environmental Group wanted to insist that they do a real legitimate environmental impact statement before getting approval. When they showed up at the hearing, however, they found that the officials who were going to be ruling on the permit for the project all had brand new luxury automobiles that they had received from Chinese sources. Um, and so this is a big problem. This year, we launched a course jointly with the University of Malawi where we had teams of students paired up, students from Malawi and students from Maryland, working on three particular environmental projects to deal with some of the tremendous public health problems that they have from environmental pollution there. Malawi is one of the poorest and most densely populated countries in Africa. Most foreign environmentalists are focusing on protecting the wildlife there. And as a result of foreign contributions, they're really pretty well protected, but they don't realize the country only has 5 sewage treatment plants and only one of them is really in working order. So they're focusing on projects that they're developing where they can assist the Malawian University of Malawi Environmental Clinic with them. Now, the US has a very robust Foreign Corrupt Practices Act that makes it illegal to offer anything of value to a foreign official in order to get an official action from them. What few people realize, but what Jingjing has focused on, is that China also has a Corrupt Practices Act. Article 164 of China's criminal code prohibits bribery. And in 2011, it was amended by the National People's Congress to extend to cover bribery of foreign officials. To our knowledge, it has never been used for a single prosecution of a Chinese company for trying to bribe foreign officials. Jingjing believes that if just one such prosecution were brought, it would have an enormous impact on the extent to which companies would avoid bribery. Also, in December of 2019, the Supreme People's Court in an opinion on providing services and guarantees for the Belt and Road Project, stated in Article 11 of this opinion that deals with environmental protection that China should proactively contribute its judicial resources to global environmental governance. The Chinese judiciary should strengthen environmental public interest litigation and tort litigation to stop environmental violations and enforce liability for damages. Jingjing's vision is that if a Chinese environmental NGO were allowed to bring a suit in China against a Chinese company for environmental violations in poor developing countries, that would have a massive effect in raising the consciousness of those corporations. Now, a major approach to try to hold these companies accountable is transparency. And it started with the Publish What You Pay initiative that tried to publish and make available on the internet what officials in developing countries were insisting on in the way of bribes or kickbacks in order to operate in their countries. That then led to other legal actions where the US in the Dodd-Frank financial reform legislation actually included a provision that required companies in the extractive industries to report every year on all payments to foreign governments. The companies were objected initially and said it would be bad for our business if we had to admit what we had, the payoffs we had to make and disclose them publicly. But in this op ed, when the SEC was considering the required regulations, a former head of contracts at the state owned oil company in Libya basically said if this information had been made available, Muammar Gaddafi would never have been able to have stolen billions that belonged to the Libyan people in bribes and kickbacks to oil operations there. She said if you allowed an exception for when the foreign government objects, this would be called the tyrant's veto. Now, what's so unfortunate is that when the US Congress enacted Section 1504 of the Dodd-Frank Financial Reform Act, it spurred similar initiatives around the world. In the EU and in Canada, other countries were also requiring disclosures of payments by extractive industries. And that lasted until President Trump took office, issued this executive order just 2 weeks after taking office. And actually, he asked for a report from the Treasury on how to make capital markets function better. And the report came back and said, let's repeal Dodd-Frank Section 1504. Well, the Extractive Industries Transparency Initiative now has become sort of the gold standard for improving transparency by mining, oil, and gas companies because it's set up a very elaborate process for ensuring that these companies have to disclose what their real agreements are with officials in these countries, that this information becomes available to the public and civil society groups, and they have a very detailed validation process to make sure that various developing countries are making progress towards the required transparency. President Obama had the United States join the Extractive Industry Transparency Initiative, and we had just been certified. As you see there in the 2015 and 2012 and 2015, 2012, we're making progress. 2015, we're now in candidate, and we eventually became compliant. But then the first year he's in office, President Trump has the US withdraw from the Extractive Industries Transparency Initiative. So today you see that North America doesn't have any members of it. So that's been a real setback to transparency the cause of transparency with respect to extractive industries. Now, of course, there's also an effort to get international principles on human rights and the environment adopted. The United Nations in 2005 appointed a special representatives on human rights and transnational corporations that led to the UN issuing guiding principles on business and human rights. The foundation of those principles are recognition of a state duty to protect against human rights violations and a corporate duty of due diligence to avoid infringing on human rights. And it extends not just to the parent corporation, but also to their subsidiaries. In February of 2017, the National Assembly of France adopted an innovative new law, the French Duty of Diligence Law. Uh, the law actually is legally enforceable. It's not just a voluntary initiative with penalties, and citizens can sue for violations of it. It requires that companies be proactive in ensuring that they're not committing human rights violations when they operate in the developing world. They have to set up procedures for ensuring that they're respecting human rights and the environment. And the first lawsuit that was brought uh, under this law was brought against the French oil company Total for its oil operations in Uganda. Uh, and unfortunately, the French courts said, oh, you should have brought this in a different court. This is really a commercial dispute. It's not something that should be brought in the regular French courts. So as a result, uh, they did not lose on the merits. It was more a venue issue in the decision that was issued in January of this year. But it's hoped that these type of initiatives could eventually result in a UN treaty on transnational corporations and human rights. The UN Human Rights Council in 2014 established an intergovernmental working group with the objective of developing an international legally binding instrument to regulate transnational corporations with respect to human rights. Uh, Draft has been developed, and there's powerful support from civil society for moving to adopt such a treaty. Unfortunately, US corporations and Chinese corporations have not been very enthusiastic about this. And some have argued that, well, this is a pipe dream. The UN is not going to adopt anything like this. And if it does, it will never be ratified by the countries that count. Um, and the most recent negotiating session suggests some disappointment in that it already has been kind of watered down, but it is certainly going to be the focus of a lot of activism by environmental and human rights NGOs. There are other initiatives to promote transnational environmental accountability. The Brookings Institution, as a way of fighting corruption, has developed this TAP Plus approach that focuses on how to improve transparency in the dealings that multinational companies have uh, in the extractive industries with developing countries, how to promote accountability, and how to include greater public participation so that the communities who are so affected by these projects in developing countries are part of shaping what goes on. The Asian Infrastructure Investment Bank, which has helped fund much of the Belt and Road projects, did in February 26 adopt an environmental and social framework that was designed to um, encourage companies that receive funding from it to improve their record on environmental protection and human rights. It requires those companies to adopt appropriate measures to avoid, minimize, mitigate, offset, or compensate for adverse environmental and social risks. But there's considerable skepticism about this. Among other things, the bank has pledged to combat climate change, but there's nothing in this policy that prohibits the AIIB from funding coal projects. Although it requires consultation with affected indigenous communities, it fails to create any effective grievance or enforcement mechanisms in cases where that consultation is not successful. The latest environmental issue of Environmental Forum, the September-October one that's about to come out, has this column by my friend Bruce Rich, who is taking Chinese companies to task for the fact that it's supposed to be Chinese government policy to greatly reduce reliance on coal as an energy source, at least in China. As we've been studying in my comparative environmental law course these last 2 weeks, China still is heavily dependent upon coal for its energy, but it's made great strides in reducing coal use until just recently. But as Jingjing frequently points out, if all that happens is that China reduces its domestic coal use while it funds projects that build coal-fired power plants in the developing world, the result's not going to be good for the planet, because when you're dealing with climate change, your concern is planetary and not just what happens to China's domestic environment. So, in conclusion, a half century ago, when Texaco went to the jungles of Ecuador to extract oil, multinational corporations felt free to use lax environmental practices. The government of Ecuador basically had no standards at the time, and Texaco engaged in practices that no responsible oil company would have used in the developed world, leaving behind an environmental mess that persists today. This has caused enormous environmental damage and social dislocation in many parts of the world. Today, at least, a global network of concerned and increasingly sophisticated NGOs guarantees that no company can despoil the environment in a remote corner of the world, confident that its practices will escape scrutiny. Greater transparency has inspired some companies to improve their environmental practices in the developing world, but it has had less impact on state-owned enterprises, many of whom are based in China. I maintain that transnational environmental accountability has become a global imperative, but much more work remains to be done. So I'm going to stop sharing the slides there. So,
Great. Thank you so much. To our audience, we do have a few minutes to ask some questions. As a reminder, for those of you watching on our website live stream, you can click on the watch on live stream icon at the bottom of the video to bring up the chat box, and you can add your questions. If you are watching on our Facebook live stream, add your question to the comment box below, and we will try to get through as many questions as possible. First question, the multidisciplinary team approach that was utilized with US attorneys and students combined with um, folks from China and Africa, are there any lessons learned from that kind of multinational collaborative approach that could be utilized in other environmental conflicts?
Well, I think the first most basic lesson is that you can't just parachute in and think that we have all the answers because environmental law is so much better developed in the United States and we have more experience with it. It's absolutely essential to uh, consult the local population, find out what their needs are, and how you can be of help to them. Having a diverse, multidisciplinary group that knows how you can do citizen science, what the local population could find out about the impacts of those projects is going to be useful, particularly if you've got lawyers from the same country as the company that's doing the resource extraction and able to argue that they're not only violating local law, but also violating Chinese law. We had planned a major conference for April where we were going to bring over from Africa the leaders of some of the top NGOs in various countries there. And we had the head of Harvard's Human Rights Clinic was going to speak, as well as Alfred Brownell from who had to flee Ghana after being an environmental activist there, and he's now at Boston University, and really have a time to sit down and map out a strategy for how we can be of assistance. It's great that there are many groups that are doing that. eLaw International funds these fellows and gives them training and resources, but there's so much need out there that you can't do too much. Unfortunately, that conference had to be canceled due to the pandemic and the subsequent lockdown, but we're hoping we can figure out a way in which to hold a similar thing, even if virtually later this year. So as we discovered from the course with Malawi, it actually was very useful in getting our Zoom skills up to speed before the pandemic hit, because we've been doing the course by Zoom. But we also learned that when the US went on daylight savings time, suddenly we were on a different hour than they were, and one or the other of us had to adjust when the class was going to be scheduled in the curriculum for that. So that will always be a challenge with some of the remote classes, but we're all getting better at it, I think.
Yeah, absolutely. So your students at Maryland participated in this, and there are a lot of students interested in international environmental law now. Can you help students who are enrolled now understand why doing work focused on China specifically is an important part of learning international environmental law?
Yeah, I actually, when I started work in China many years ago on environmental issues, uh, there were two main motivations. First, China is the one country that has the greatest impact on the entire environment of the planet. It has more people than any country. It emits more greenhouse gases than any country, and now it's seeking to dominate infrastructure investment in the developing world. Because US environmental law had already become sufficiently mature, I had the distinct impression that the same amount of effort devoted to helping China improve its environmental laws would pay much greater dividends than the same amount of effort in the United States. So I think those are two compelling reasons for why the focus on China is such a good one. And also, And this surprises a lot of people who haven't really spent any time or spent any experience in China. And that is that while China is a one party authoritarian state, the Communist Party has been strongly, sincerely, genuinely pro environment now for decades. They really are serious about having an ecological civilization. Now, you might question the motive. Some have said the reason they're doing it is environmental conditions got so bad that some days you had to shut down the airport because air pollution was so bad that 1.6 million people die every year from Chinese air pollution. And the party was afraid that this would cause civil unrest and might be their undoing if they didn't effectively respond to environmental problems. But that has made it easier to work there because unlike other, human rights or other issues in China where you would face constant harassment and pushback from the government, that doesn't happen there. Just a year ago, last May, I was invited once again to lecture to new Chinese environmental judges. And we had a workshop of passionate debates comparing US cases with cases in China's environmental courts. They've got nearly 1,000 environmental courts now in China. And so it's a real pleasure to work on environmental issues in such an atmosphere.
And are you able to speak to how that ecological principle has played out in other communist countries like Russia?
Well, it all depends on the leadership. And um, Russia is sort of a sad case. I actually went over there in 1987 to give some of the first public lectures on environmental law. It was in the wake of Chernobyl, which helped bring about the downfall of the Soviet Union. It was still the Soviet Union at the time. And St. Petersburg was then Leningrad, but they let me teach a class on environmental law in Leningrad State University for a week. And it was clear that the Gorbachev regime realized that it should be more pro environment. At the same time, the Natural Resources Defense Council was trying to promote local grassroots environmental groups. But a lot of that, there are some very courageous environmentalists in Russia and courageous NGOs. But the one thing that Putin seems most concerned about is protecting the Siberian tiger because it helps his macho image. He dissolved the Gospромpriroda, the state environmental protection agency, and folded it in another agency. So I think you would probably find a lot of hostility to environmental initiatives from the Russian central government, although there are a lot of courageous environmentalists working there. We can only hope that someday the government adopts a better attitude towards environmental measures.
And this question is sort of a follow-up on your comments earlier about the multidisciplinary team approach. But if you were to summarize, based on your work in China and other countries, what do you see as the role of the U.S. in working with foreign countries when it comes to issues like accountability for environmental harms that are local to other countries?
Well, the one thing that the US enjoys is it still has, despite the blip of this horrid administration that's trying to roll back all environmental regulations, one of the longest histories of support for environmental protection around the world. EPA will turn 50 in December of this year. And last fall, Case Western Reserve Law School had a conference on EPA at 50 in anticipation of that. And I was one of the speakers they invited because I guess I'm old enough that I remember a lot of this history. But I wrote a piece that's going to be in a symposium issue on EPA at 50 that traces the role EPA has played as a catalyst in the development of global environmental law. starting from the first agreements between EPA in the middle of the Cold War with the Soviet Union to do things like climate research and the like. And it's clear that that agency still has an absolutely stellar reputation among other countries because it has done so many things. And the purpose of my piece was sort of to document a lot of the hidden things that don't get a lot of publicity that EPA has done to try to promote better environmental conditions around the world. And one example was phasing out lead in gasoline and how rapidly that spread to the point where it's virtually universal around the world now that there's no lead in gasoline. We fought a long and hard struggle, and the Reagan administration tried to get rid of the limits on lead in gasoline. But ultimately, when the US phased them in, it proved so enormously beneficial in reducing levels of lead poisoning in children's blood that the rest of the world followed along. And that's one of the greatest environmental achievements in world history, spearheaded in part by the leadership of EPA, and in particular, Bill Ruckelshaus, when he was brought back to EPA to be administrator once again in the latter part of the Reagan administration.
Okay, great. I think we have time for one more question. You've spoken mostly about what I think are point sources in terms of sources of pollution. Do you have any experience working on non-point sources like agriculture in this international context?
Well, yeah, actually, this afternoon, my comparative environmental law class is discussing China's new soil pollution prevention law, and yeah, it's clear China's law has dealt a bit more with agricultural pollution than the U.S. has done. To date, most of my experience on agricultural pollution is the lawsuit that our environmental clinic brought against the poultry industry for polluting the Chesapeake Bay with chicken waste. We learned a lot as a result of that lawsuit. The defendant spent literally millions on public relations to try to demonize our environmental law clinic. We were condemned by the supposedly progressive governor of Maryland, Martin O'Malley, who had been a college roommate with the general counsel of the chicken company we were suing. But what's come out of that in the US is actually that there's much greater compliance among farmers on the Eastern Shore with the environmental regulations that they're supposed to pay attention to. And we actually created a program of providing legal services to the farmers. And I think that's an approach where you can't just go charging in with a lawsuit. You really need broad support from the community. And that's an approach that will serve you in good stead wherever you are in the world.
Yeah, you're certainly from a part of the world that is experienced with non-point source pollution in water bodies, the Chesapeake Bay. Okay, well, for our listeners, we are out of time. Professor Percival is teaching at 1 o'clock, so we'll give him a few minutes to transition. Thank you so much to Professor Percival for your presentation, and thank you to our viewers for joining us today. Our last Hot Topics talk will be this Thursday on July 30th, and we hope that you can join us then. Thanks, everyone. Have a good afternoon.
Thanks, that was fun.